Congratulating the Minister on doing as he has described. I thought that the way in which Parliament's conducted itself in respect of this legislation in the last week has actually been exemplary, and it's actually the sort of interchange that we should have in respect of pieces of legislation that actually the public want us to do. We've actually built public confidence in this institution this week, and were there to be another ranking of the most trusted New Zealanders next week compared with last week, maybe we'd come up a notch. I suspect we still wouldn't be in the top half, returning to the merits of this legislation, there has never been disagreement that we ought to take advantage of this technology for things that don't adversely affect the interests of parties to litigation. So using audio-visual technology to making it cheaper and quicker and more convenient for people to participate in civil proceedings and particularly in call-over proceedings for criminal matters is to be applauded. The area where the opposition was very concerned was in respect of the ability for a judge to have a discretion to conduct a trial without the accused having the right to be present. And I do want to dwell on why that seemed so clearly to be wrong, but perhaps more on the process which led us to being so close to abrogating that civil liberty, because I think that it's actually pointed to perhaps a mistake that was made within the ministries. When I started to think about this after we heard from the Human Rights Commission and the New Zealand Law Society as to their opposition to it, and tried to think about how injustices could be caused to the accused, it quickly became apparent to me that there are a number of ways in which an injustice could occur. And I've listed them previously in other stages in the debate, but I'll mention a couple of them now, or some of them now. For a start, the right of the accused to participate by audio-visual link could be frustrated at the Corrections Department end if you had Corrections Department officers who wanted to be disruptive. You could also have technological faults. It's a matter that I hadn't previously raised, but there can always the possibility of technological failures, and we see that often enough in select committees when we hear submissions at a distance by way of audio-visual link. But in addition to that, there are various things that happen in a trial that accused must be able to see, both in order to protect the accused's interests, but also to maintain their sense of fairness, that they've been dealt with fairly by the justice system. And that's important in terms of maintaining public confidence in justice. Now, one of the particular things that would worry me is if I was an accused and I had someone giving the main evidence for the prosecution and they couldn't see me staring at them at the time they were about to give evidence that was adverse to my interests and I knew to be incorrect and that they were perjuring themselves. I actually do think having to stare at the accused, the person that's going to go behind bars if they're convicted, does affect the tension that would be upon the witness, and therefore it affects their demeanour when they're giving evidence, and therefore it affects whether their evidence will be believed by the judge or the jury. There goes one instance where it's important that the accused is there able to face the accuser. Another instance is what can go wrong in a courtroom. You can, on occasions, and these are very rare, but you can have inappropriate sort of cosy relationships between the defence and the prosecution. That sort of thing is less likely to happen if the accused is present. And if it does happen, it's important that the accused is there to see it, so that the accused can say, hey, this isn't on, and sack his counsel or her counsel. Inappropriate things can happen in the juries. The juries can fall asleep. Juries could be handing around pictures that are irrelevant or haven't been gone through the normal evidence process, and the accused has got a right to see whether that's happening so as to protect his or her interest. The accused has got the right to see whether someone in the galleries showing signs that might be pejorative of the accused. The judge might be have had prior dealings with the accused and be tempted to make snide remarks or inappropriate remarks about the accused without the accused presence. The accused has a right to know if those things are going, so that if those things do go down, the accused knows that they've gone down and can protect his or her interests both at trial and any subsequent proceedings like appeals. So I think it's pretty obvious that this was a substantial abrogation of the current civil liberty that we all have to personally attend a trial where we are accused. And I was very gratified that members of the government actually were acknowledging some of these arguments. And can I thank Simon Bridges for digging out some of the cases that he dug out and that were referred to also in the report to the Attorney General by Crown Law, where he noted that there are some instances where the accused is not able to appear at their own trial. But when we dug down into those cases, we found that was where the accused wasn't there because the accused didn't want to be there because they'd absconded from the trial. And that shows those cases to be different from the more general principle that could have been brought about had the government not brought for or agreed to amendment right at the end. I've read the report dated the 27th of November 2009 to the Attorney-General from the Crown Law Office. And it said, and I quote from paragraph 5, "The use of AVL for the appearance of an accused person at trial appears to be uncommon in comparable jurisdictions, at least without the accused person's consent." So it actually noted that there could be a problem, but then I have to say it was an incredibly once over lightly to the response once identified. And you know, not one of the instances of possible injustice that I have referred to in this short speech is referred to in the analysis from the Crown Law Office to the Attorney-General. And I personally think that that is a mistake. I won't call it slack, I just think they've made a mistake. I think they made a mistake not to be aware of what I think are pretty obvious possibilities of injustice from this. And they should have been alert to that from the fact that even in their own report they say it appears to be uncommon in comparable jurisdictions, at least without the accused person's consent. So I, for one, am have a little bit less confidence in Crown Law than I did before I read this report, because I think they've made a mistake. And I hope that they learn a lesson from this, and they've seen that actually when this has been debated in Parliament, that actually Parliament has seen fit to actually be a bit more protective of our civil liberties than they thought was appropriate when they were assessing this in relation to the Bill of Rights. In terms of the advice that came to the Select Committee, I thought the Ministry of Justice departmental report was less than perfect as well. Again, its analysis at paragraphs 65, I think it is, and around there, again, I thought was a bit general. It sort of tried to sort of bluster that these things were happening overseas, when actually, if you read it in detail, you saw that there wasn't much justification based on overseas jurisdictions. And when you looked at Canada, they can't do it without the consent of the accused. And when you looked at most parts of Australia, that's the same too. And maybe Australia is a wee bit different because of their huge geographic distances. That point was never brought out either. We never heard what was the case in the United States, but I'd be very, very surprised if you can't have a trial there without being personally present. And in the United Kingdom, they've only got some pilot trials, so they certainly haven't got this rule over there either. So we were going out on our own, in my opinion, and that didn't come clear from the departmental advice that was provided to us at committee, and we as committee members had to dig in order to find that. Thank you, Mr. Speaker. In respect of the conduct in this House, I also thought that Wayne Mapp, in the Chair, made an appropriate acknowledgement at one stage when he did concede that the change from having a unconditional right to appear at your own trial to one that was effectively at the discretion of the court, albeit with some protections built around that discretion, was a significant change. And I think that was an appropriate acknowledgement for the Minister to make in the Chair, and I thank him for doing it. But it did then raise the question, well, if the Minister and the Chair can see that, and if we in this Parliament can see it, why couldn't Crown Law see that that was a significant change that actually required some proper analysis in terms of the Bill of Rights? Then, of course, we came to the intervention of the Minister, and the Minister had been listening to the debate on the facility that we have here, and presumably in his office, and was sufficiently moved by the importance of these issues to come to the House. Minister, thank you for doing that. I know that on both sides of the House at times that doesn't happen, and it's pretty hard to change track when you're going and you've got departmental advice that you're right, and you've been to Cabinet and Cabinet's been convinced that you're right. It is actually quite hard to change your mind in these processes, and it shows strength of character on your part that you were able to do so. It also shows the respect that you are held by your Cabinet colleagues, that you had the confidence that you could do that and your Cabinet would support you in doing so. So I do want to put that on record. I think in the end this actually shows that this Parliament can work to protect civil liberties. We have done so in this case. I was very concerned until the last that we weren't going to get there. We had put up amendments to similar effect to the amendment that the Minister put through last night, which was voted on first, and the indication was that those amendments were going to be voted apart. Can I thank Mr Garrett and members of the ACT Party, members of the Maori Party, member of the Green Party for their for their involvement in this and